This is our Supreme Court WebQuest presentation.
By Mackenzie Trujillo and Matthew Vallon.
Supreme Court Chief Justice Salmon P. Chase. Salmon P. Chase was born in Cornish, New Hampshire on January 13, 1808. He was the ninth of 11 children and the child of Ithmar Chase and Janet Ralston Chase. After his father died, he moved to Ohio to live with his uncle. He attended Cincinnati College in 1822 and Dartmouth College. He graduated in 1826. After graduating college, he went to Washington, D.C. and worked as a teacher. After working as a teacher, he studied law under U.S. Attorney General. During his professional career, he was a lawyer, politician, and a judge. Salmon P. Chase spent his early career as a lawyer. He was a senator from Ohio from 1849 to 1855 and became Abraham Lincoln's Secretary of the Treasury. After Chief Justice Roger Taney died, Abraham Lincoln appointed Chase to serve as the Chief Justice of the U.S. Supreme Court in November 1864. One case that Salmon P. Chase was involved in was Viazzi Banks v. Fenno in 1869. Salmon Chase was a part of the majority opinion which stated that Congress had the power to pass Act on July 13, 1866. This imposed a 10% tax on notes of state banks and state associations. A second case he was involved in was Hepburn v. Griswold in 1870. During this case, Salmon P. Chase spoke for the court as Chief Justice. He declared certain portions of legal tender acts as unconstitutional, such as the greenback issuance. While Chase was senator, he fought against expansion of slavery. Chase was also nominated for presidency in 1856 and 1860, but failed because of his views on slavery. His face is on the $10,000 bill, and he had a hard life, meaning his first wife died 2 years into their marriage, followed by their daughter at the age of 5. His second wife and 2 of his 3 daughters also died. Lastly, his third bride died 6 years later, followed by one of their 2 daughters. Salmon P. Chase died of a stroke in New York on May 7, 1873.
Supreme Court Case Miranda v. Arizona. The case began with the 1963 arrest of Phoenix resident Ernesto Miranda, who was charged with rape, kidnapping, and robbery. The case happened when Ernesto Miranda was arrested in his house and brought to the police station, where he was questioned by police officers in connection with a kidnapping and rape. The case originated back in Phoenix, Arizona, when Miranda was questioned by police detectives and a prosecuting attorney. He was interrogated for 2 hours, where he signed a written confession. The confession of Miranda would be used as evidence against him in trial. Miranda was convicted and sentenced to 20 to 30 years in prison. Miranda's attorney appealed to the Arizona Supreme Court, then later to the United States Supreme Court, which agreed to hear it. Throughout the case, he was questioned by police detectives and a prosecuting attorney in a room where he was separated from the outside. In none of the cases was he giving full effective warning of his rights. The police failed to inform Miranda of his First Amendment, protection against incrimination, and 6, right to an attorney. The Supreme Court voted a 5-4 decision written by Chief Justice Earl Warren. He ruled that the prosecution could not introduce Miranda's confession as evidence in a criminal trial because the police failed to first inform Miranda of his right to an attorney and against self-incrimination. The decision gave rise to what has become known as the Miranda warning. Ever since Miranda v. Arizona, whenever a person is taken into police custody, before being questioned, he or she must be told their Fifth Amendment right to not make any self-incrimination statements.